Hello and welcome to the PINCast, the podcast presented by myself, Richard Bowser, editor and founder of Property Investor News, the monthly magazine which we launched 20 years ago back in 2002. If you want to listen to factual, no-nonsense interviews, insight and opinion from some highly experienced and respected property professionals, then this is the podcast that you really need to tune into on a regular basis. In today's episode, we're discussing the Renters' Rights Act with Mustafa Siddiqui of Thackeray Williams and what it means for landlords across the UK. This is one of the biggest legislative changes in decades, and if you're not prepared, it could significantly impact how you manage your property portfolio.
Hi Mustafa. So, in simple terms, what is the Renters' Rights Act and why does it matter right now?
Hi, so Renters' Rights Act received royal assent in October 2025 and it's been implemented on the 1st of May this year, and it's very, very important because it's effectively reformed landlord and tenant legislation more than at any time in the last 40 years. What it's done, it's removed or is removing the old assured short-hold tenancies for existing and forthcoming tenancies and bringing in new periodic assured tenancies. So it's a massive change between the relationship of landlord and tenants.
What's the biggest change landlords need to be aware of?
The largest changes are firstly the abolition of Section 21 notices, which are no-fault evictions. Secondly, there's changes in what one can put into a tenancy agreement. So you can't have rent review clauses anymore, you can't have more than 1 month advance rent, you can't restrict a tenant's ability to have pets in a property. There's also other equality and diversity clauses that are being incorporated in. So it's restricting the landlord's ability to put what they want in an agreement.
How does scrapping Section 21 actually change things for landlords?
So Section 21 is the no-fault regime. So usually one would serve a Section 21 notice. That would give 2 months for a tenant to vacate. If they didn't vacate, you would file accelerated possession proceedings, which is a paper exercise. And if you've got all your ducks in a row in terms of deposit protected, gas certificate, EPC, the court on the papers would grant possession. It's a much quicker way of doing things. Now that's being scrapped, one has to serve a Section 8 notice and follow the court procedure. So I'm having inquiries today from landlords who are wanting to sell their property or put family members into that property, and they're not going to be able to do that after the 30th of April. They're going to have to go down the Section 8 notice, which rather than giving you 2 months notice, you're going to have to give 4 months notice. And after that 4-month period, if the tenant doesn't leave, you'll have to file court proceedings, and that could take a year for you to get a judgment. So it's taking a lot longer, and it's obviously more costly because a tenant could oppose or they could do things to drag the procedure out.
What should landlords be doing right now?
So there's 2 very important things landlords need to do right now. Landlords have to serve information upon their tenants in relation to the Renters' Rights Act by the 31st of May this year. If they don't do that, there could be a fine of up to £7,000. So you can go on the government website, print off the information and serve it upon your tenant. Now, service would be what is good service under your tenancy agreement. It might be the fact that you can email it to your tenant, you might have to post it, you might have to hand serve it. It depends on what your existing tenancy says. Secondly, because there's new rules being placed about having pets, about advance rent, about rent increases, those are being scrapped under new legislation. So you're going to have to serve upon your tenant a short note setting out the new terms of the tenancy. That's not to say a new tenancy agreement, but just tell them which clauses are no longer applicable, which are redundant, and which are remaining in place.
What happens if landlords miss that deadline?
So there's 2 deadlines. There's one about the service of Section 21 notices. So if by the 30th of April you haven't served a Section 21 notice, you're no longer allowed to do so. So today I'm being asked by clients to draft and serve notices. I'm advising clients to hand serve their Section 21 notices at the tenant's address so they can assure and they can evidence the fact it's been served. If we post it today, there's a chance it doesn't get posted in time and isn't a valid notice. In terms of giving the information to the tenants about the new legislation, they've got to do this by the 31st of May, and if they don't, there is a fine of up to £7,000. So they have to go on the government's website, print off the information form, and, as I said, either serve it by hand or by email or by post, as prescribed in their agreement.
What's the one mistake landlords should avoid?
Making their notice invalid. So, as with the old legislation, you have to have your gas safety certificate, you have to have your deposit protected, you have to give them the prescribed information. All these requirements are still in place if you want to serve a valid Section 21 now. Also, service doesn't mean just posting it, it means that it's been received by the tenant. So you can either have recorded delivery, but I suspect you wouldn't get the deadline, or you can hand serve it and video yourself or photograph a notice being affixed to the door of the property so you can evidence service. Because the first thing a judge is going to do is, what is the proof of service?
How will moving from fixed-term tenancies to rolling tenancies affect landlords?
So first of all, there's some clauses which are no longer lawful. So more than 1 month rent in advance, the inability to have pets in your house, and furthermore, in order to get possession back from a tenant now, the notice periods are longer. So under the Section 21, it was 2 months. Now, even if there's a fault, if someone isn't paying their rent, whereas it used to be a 2-week notice and 2 months arrears, now you've got to give 1 month's notice and the rent arrears have to be 3 months. So that adds more time to the timetable of getting possession back, and that's before you file proceedings and have to wait a year till you have a trial and get judgment. Anecdotally, I'm being told by landlords that their tenants are telling them that local authorities are saying, don't vacate a premises if you've been served with a notice, stay in the property until you're evicted by a bailiff. Because there's so little social housing, they want to draw it out longer. So local authorities are saying to tenants, stay as long as you can. The pool of private residential properties are shrinking because of all these legislations. So there's less property on the market, and obviously there's more people trying to get less properties.
Will it become harder to regain possession of a property?
It will become harder, and it will also take longer. As said previously, your notice period is going to be longer. It's going to take a longer time to get to court. So you're going to have a tenant who's potentially not paying rent in your property for a longer period. There's also going to be more possessions taking place because of these implemented legislation. So there's going to be even a longer time to get a hearing.
What reasons are landlords giving you for selling up?
Over and above the Renters' Right Act, which landlords perceive is going to make it harder for them to get possession, there's new rules coming into play in relation to energy performance. So from 2030, you're going to have an EPC C standing in order to rent a property. There's also this make tax digital rules coming in. So if a landlord has an income of more than £50,000 a year, they're going to have to go online to do their tax returns. This is difficult for small landlords. It requires more infrastructure. Over and above that, there's going to be a landlord register. So at the end of this year, there's going to have to be a list of all the residential landlords in the country. In addition to that, because it's going to take longer for landlords to get possession where tenants are in breach, landlords are scared. Another issue is the perception of increases in buy-to-let interest rates. Now, there's been some talk about this coming down, there's been some talk about this going up, but landlords are making less money because it's costing them more. Also, we have the 2% tax increases from April 27 on residential earnings from landlords. Under the old Section 24 rules, it was you were taxed on the profit. Now you're taxed on the entire income. So there seems to be less money for landlords to make, unless you're a large landlord with a great corporate infrastructure who can manage all these changes. And for landlords like that, there's going to be a lot of properties coming onto the market. So for them, it's a positive thing, but you can buy cheaper properties and increase your profit that way.
How do the upcoming tax changes add to the pressure on landlords?
So from April 2027, there's going to be a 2% increase on residential tax. So even if you're a 20% taxpayer, you're going to be paying 22%, 40%, 42%, and 47% if you're a highest rate taxpayer. So this is obviously cutting out profits for residential landlords and increasing their burden. In addition to this, the fact that there's going to be higher borrowing rates, because from the end of this year, all the COVID rates, the lower 1 to 2% interest rates buy-to-let mortgages have come to an end. Anecdotally, I'm being told it's 5 to 6% now. So that's a huge difference. It could be £600-700 a month difference in landlords' costs.
Do you expect rents to rise as a result of all of this?
I do. So I understand from research that last year there was 208,000 residential landlords sold their property. This year it's envisaged there's going to be 220,000 residential landlords selling up. And this is a direct result of all these, the renters reform and the tax, all the issues that these landlords are facing. So with a smaller supply and increasing demand from tenants, rents are going to go up. Given also that social housing providers and local authorities are telling tenants not to leave when they're served with notices because there's a lack of social housing, you're going to have far more tenants on the market looking, so rents will go up.
In your opinion, is the government intentionally reshaping the PRS towards a more professional model?
I think they are, and I think the intention is good in the sense that what they're trying to do is make the legislation more supportive of tenants and make the requirements on landlords to behave decently enshrined in law. The counter side to this is that accidental landlords who, say perhaps a couple who moved in together and found themselves with a spare property, are now being forced out of the market because you haven't got the infrastructure when you're an accidental landlord to adhere to the new rules. For example, the making tax digital, for example, the EPC, which is going to require a minimum expenditure of £10,000. If you can show you've spent £10,000 on making a property compliant with the EPC, you don't have to go further than that. But on average, a 1930s semi or a mid-terrace is going to cost about 10 grand to make EPCC.
For landlords who want to stay in the market, what should they be focusing on?
So the most important thing is the EPCC. So if you've got a couple of properties, you have to make sure that all your properties meet the EPCC requirement. That's got to be done by 2030 or you have quite large fines. You also have to make sure that your making tax digital compliance is in place. So you're going to have your tax all online. You have to join the landlord's register. That's going to be mandatory. Interestingly, there's also a new landlord ombudsman coming into place. There's previously been a tenant ombudsman, but now if there's a dispute between landlords and tenants, you can go to the ombudsman, which is supposed to be a free service to try and resolve issues without the need of going to court. So if there's potentially an issue of disrepair or potentially an issue of a breach of tenancy, rather than going to court and enforcing it, the Ombudsman will be able to deal with these things. So you need to get your ducks in a row in that regard to make sure you're adhering to legislation.
Looking ahead, what will a successful property portfolio look like after these changes?
So a successful property portfolio would have all tenancy agreements adhering to the new legislation in terms of being assured periodic tenancies with no all clauses set out properly. The landlords will be part of the landlord's database. You would have all your EPCC certification in place for each of your properties. Your online tax would be in place, ready. Usually that's via a corporate entity as opposed to an individual. So more landlords are becoming limited companies in order to make it easier for their accountants to adhere to these tax requirements, because especially in the southeast, most landlords are going to have an income of more than 50,000 if they've got a couple of properties.
If you had one piece of advice for landlords, what would it be?
I would advise landlords to get legal advice urgently. The reason for that, there's so many new rules coming into play, and it's being drip fed by the government, and really only solicitors and block managers and landlord and tenant professionals are aware of the legislation and the rules. You don't want to slip up on something, so get proper legal advice so you don't miss anything.
Thank you for listening to this latest PINCast from Property Investor News. Make sure you've subscribed to be notified when the next episode is released. Register for the PIN e-news service at www.property-investor-news.com, where you can also sign up as a magazine subscriber and get the monthly print magazine. By subscribing to the magazine, you can get access to 17,000 articles which we've published in the last 20 years, alongside some 300 webinars and video interviews.